Welcome everyone to the SA Business Chamber's webinar, Redundancy 2026, where we'll be looking at statutory compliance and providing you with some case law spotlights. My name's Karen van Gorp. I am a Policy and Advocacy Senior Advisor with the Chamber, and with me today and presenting the bulk of this presentation will be Andrew Tulic and Sophie Katsaros, both of whom are senior workplace relations consultants with significant background in workplace relations, and they are the centre of our workplace relations consultancy. Just a quick disclaimer, as usual, if you need specific advice, I advise you to contact our consultants, and at the end of the session today we'll look at what other opportunities there are for you to get assistance from the Chamber. But in particular, we'd like to say that what we're providing today is general, it's not legal advice, and we accept no responsibility for any inaccuracy in the content. We'd also like to say that today is funded by, and which is why we can provide this sort of information for free, is provided by, funded by the Education and Training Fund, which is a federal government department funding program, and it enables us to provide information, especially with so much changing at the moment for employers. Today's agenda, what we'll be looking at is redundancy, what it is, and how it can impact you. We're also looking at consultation obligations, and we're also looking at redeployment considerations. And in particular with redeployment, it's something that you can do for employees. Give us a call, because there are some opportunities for you to provide some support to redeployed or redundant employees in particular, where we can connect them with an organisation that will actually help them find other work if that isn't possible within your organisation. So please contact us, and we will be providing information. Keep an eye on our newsletter, because we will be providing some information on that in the next few weeks. Questions, we have a few questions that have come up, which we will, as appropriate, address throughout the seminar. If you have specific questions, please email us. You will have received this. You will receive this as a recording, and please send a return email if you have any specific questions, and we'll get the right people to give you a call back. Welcome, Sophie and Andrew.
Well, thank you, Karen, for your kind introduction. So firstly today, we're going to be talking about the most important thing to establish and understand about redundancy is that it's a numbers game, meaning that one person's particular job is no longer required. Redundancy occurs when an employer no longer needs a job to be done by anyone because of an operational change as defined under Section 389 of the Fair Work Act. You might employ 9 people in the same job, but you suddenly, for operational reasons, at one point only require 8 or maybe less. It is about the job as enshrined in an employment contract and not the person. This could mean, in one scenario, that redundancy will occur where there is not enough work for a full-time role and the employer wants to change the role from full-time basis to a part-time basis. It could mean that the part-time role could be a suitable alternative form of employment that is offered as redeployment. Redundancy can happen where, 1, the need or demand for the performance of a person's duties may have diminished to an extent that the employer no longer requires that role to be performed, Or 2, a restructuring or reordering of duties within a business might result in either the duties being distributed to other positions, first position redundant, or the duties being so largely changed that a position of a different nature is created, making the first position redundant. Or thirdly, a reduction of one or more roles where there are multiple within an organisation, as described before, where, for example, you may have a removal of, let's say, one warehouse store person out of 9 from a warehouse situation. Redundancy in the first situation, where you only have one of those roles in the organisation, is simpler because you don't have to go through the objective selection and assessment process to identify which of those roles will be made redundant. So when looking at redundancy, to be clear, a redundancy does not occur where there are changes to the ordinary and customary turnover of labour, or because of the insolvency or bankruptcy of the employer. The obligation to make a redundancy payment won't apply if the termination occurs due to the ordinary and customary turnover of labour, or because of the employer's insolvency or bankruptcy. So, in the situations of a non-redundancy, the concept of redundancy has existed since the 1980s and arises from the termination, change and redundancy cases, what we call TCR cases. The key findings of the Helensburgh case relate to genuine redundancy and what it means for employers who must avoid disguising a dismissal as a redundancy when it is in actual fact perhaps for other reasons. So when looking at the ordinary and customary turnover of labour, one of the exceptions has caused controversy for approximately 30 years. Ultimately, it will be of very little use or assistance to most employers going through a redundancy. Where a termination is due to the customary and ordinary turnover of labour, an employee should be aware that such a termination is a feature of their employment because it should be ordinary and customary within their workplace. They should have seen it happen to other employees. Their employment contracts and ongoing employment should be tied to or dependent on some event or set of circumstances continuing to exist. The quote above there is from the decision of Compass Group Australia and the National Union of Workers and United Firefighters Union of Australia in 2015. In determining whether the termination of employees was due to the ordinary and customary turnover of labour, the Commissioner noted that, quote, "I am not satisfied that the employment of these employees was intermittent or limited to the fixed term of a particular contract. The employees selected in this case had a reasonably settled expectation of continuing employment." The Commissioner also said that, quote, "The businesses where there is intermittency in employment because of the nature of the business, these are businesses where employment or part of it is seasonal, casual or linked to the duration of a particular contract or task. These are situations where the employee has no reasonable or settled expectation of continuous or continuing employment. This will often be reflected in the casual, seasonal or fixed term or fixed task nature of the employment arrangement." Among the Commissioner's reasons for rejecting Compass's defence, he found that, firstly, Compass customarily redeployed close to half of its employees at the end of a contract. The employment of each of the 8 employees extended for more than 6 years and continued through more than one extension of the Defence RMV region contract in that instance. Compass's failure to rebid for another stores and transport contract was primarily, but not exclusively, a commercial decision. Compass's failure to rebid for another fire services contract was largely due to the decision by Defence to change its requirements. The employment contracts and induction advice given to the 8 employees didn't expressly link the duration of the employment to the duration of the Defence contract. And the employees had a reasonably settled expectation of continuing employment. From this, it is best practice to use accepted fixed-term contracts, ones that aren't prohibited by the new provisions, or fixed task contracts. In short, the best arrangement and thing to do is to get advice. So in the case of a genuine redundancy, an employee cannot have been unfairly dismissed if their dismissal was a case of being exactly that, legitimately genuine. The definition of genuine redundancy is contained in section 389 of the Fair Work Act, as we've mentioned, and it occurs if the employer no longer requires the person's job to be performed by anyone because of changes in operational requirements, and it complies with any obligation in an applying modern award or enterprise agreement to consult about the redundancy, and there is an offer of reasonable redeployment. Most employees will have an applying modern award or enterprise agreement unless they are either 1, a high-income employee as defined by section 329 of the Fair Work Act, or they are an award-free employee, which applies to human resources, IT and marketing professionals, accountants, lawyers, and managerial and executive employees. Best practice is to conduct a consultation process with all employees unless they are certainly award-free. So a modern award or enterprise agreement must apply to an employee for them to be entitled to consultation. An award or enterprise agreement applies to a person if, 1, it is in operation, and 2, it covers the person and no other provision of the Act provides or has the effect that the award or enterprise agreement does not apply. There is a difference between an award or enterprise agreement covering and applying to an employee. As you can see, it must cover the employee before it can apply to them. Covering is defined as happening simply if the award or enterprise agreement is expressed to cover the employee. I think the best way to explain the difference is that covering is passive while applying is active. It's a really important difference, not just for redundancy, but for compliance generally, because it is only an offence to contravene an award or enterprise agreement when it applies to the person. So, for example, an employee will usually be covered by a modern award, even through an enterprise agreement, if it applies to their employment. We won't go through the relevance of coverage versus application for all purposes of the Fair Work Act, but it's useful to be able to identify the difference if needed. So when we look at high-income employees, a modern award will not apply to those, but it will still cover them. An employee is a high-income employee if they have a guarantee of annual earnings for the guaranteed period, and the annual rate of the guarantee of annual earnings exceeds the high income threshold, which is currently at $183,100. Section 330 defines a guarantee of annual earnings and an annual rate of guarantee. So what is a guarantee of annual earnings? It's an undertaking given to an employee where the employee is covered by an award, and it is a written undertaking to pay earnings during a period of 12 months or more, and the employee agrees to accept the undertaking and agrees with the amount of the earnings. And fourthly, the undertaking and the employee's agreement are given before the period and within 14 days after A, the day the employee is employed, or B, a day on which it is agreed to vary the terms and conditions of the employment. And lastly, an enterprise agreement does not apply to the employee at the start of the period. So next we'll look at the Peabody decision, which is the Association of Professional Engineers, Scientists and Managers Australia against Peabody Energy Australia Coal Proprietary Limited. In this matter, the mining employer made employees redundant. The union argued that they were entitled to be paid out of their accrued personal and carers' leave in accordance with a clause in the Applying Black Coal Mining Industry Award. The employer argued that the award did not apply to the employees because they earned above the high income threshold as specified in their employment contracts. The court held that the words used in section 330 indicated that something more than an agreement for a high income annual salary was needed. The section refers to an undertaking which the employee agrees to accept and agrees with the amount of the earnings. As a result, the court held that a contract and salary is not sufficient to meet the definition and that the employees were therefore not high-income employees. The takeaway from that decision is that a guarantee of annual earnings should, 1, be clear that the employer is giving an undertaking to pay the employee an amount of earnings that exceed the high income threshold, and 2, specify the start and end date of the fixed period of at least 12 months during which the earnings are being guaranteed. It also must notify the employee that the modern award will no longer apply to them as a consequence of the undertaking, and specify that the employee agrees to the undertaking and the amount of earnings. So next, if we look at the consultation obligations. So this is required where a modern award or enterprise agreement applies to the employee. The consultation clauses in modern awards are generally identical to each other, and they're triggered when a definite decision is made to introduce major changes like likely to have significant effects, for example, termination, local transfers, or loss of tenure. The crucial exception here is that generally no statutory consultation obligation exists for award-free employees unless expressly written into a relevant enterprise agreement or employment contract. So, and following on from this, an employer must give notice in writing to all affected employees of the nature of the changes, their expected effect, and any other matters likely to affect them, and as soon as practicable after the decision is made, discuss with affected employees and their representatives on the introduction of the changes, their likely effect that they may have, and measures to avoid or reduce the adverse effects of the changes on them. Employers are not required to disclose confidential information if it would be contrary to the employer's interests, and employers must promptly consider any matters raised by employees during those discussions, and it's important to keep those discussions recorded. We'll quickly look at a case example for proper consultation, and that is Taylor and Classic Sports Industries Proprietary Limited. and this was heard in the Fair Work Commission in 2025. In this case, the circumstances were that the redundancy of Ms Taylor's role was part of an ongoing review of classic sports operation that had gone on for some months. 2 new roles were created during this period, and as part of the review, there were 2 roles advertised, recruited and appointed in a process that commenced in July 2024, with the appointments being made in November of 2024. The roles were Regional Account Manager and National Teamwear Manager. Ms Taylor was not told that there was a restructure that would affect her. There had been no consultation with her and no suggestion that her role would be made redundant. Ms Taylor was qualified to perform at least the Regional Account Manager role, and she said that she could perform the role as she had been assisting in a related role for some months. Ms Taylor was not told about the redundancy of her role until the 24th of November 2024, and that was a week after the appointments to the new roles were made. It was also relevant that one of the appointments did not commence their role until the 2nd of December 2024. The employer said that because an offer was made to someone else on the 18th of November, the role was not available for redeployment when Ms Taylor was made redundant. The employer accepted that. There had been internal discussions about making her role redundant before the 24th of November 2024, that the decision to terminate had been made before the date of dismissal, and calculations of termination pay had been prepared on 21 November 2024. The employer said that it had considered making Ms Taylor's role redundant in the weeks prior to that, and had encouraged other employees to take up new roles within the business. The Fair Work Commission considered that it would have been reasonable in all the circumstances to redeploy Ms Taylor into the Regional Account Manager role. In this case, Ms Taylor did not seek reinstatement, but it would have been more interesting if she had. It would have been good to see how and whether the Fair Work Commission orders remedies in such a situation. And here the lesson is, consult and consider redeployment options as soon as practicable after making a definite decision to restructure. Thank you. Now I'll pass on to Andrew.
Thanks, Sophie. Thanks very much. So this slide here is to drive home the point that a redundancy does not necessarily mean a termination of employment. It will almost inevitably lead to a termination of employment if no suitable alternative employment is available or the employee declines to accept an offer of redeployment. In cases where there will be a reduction in headcount as a result of a downturn in business, redeployment is going to be limited, if not impossible. If the primary operational reason is to reduce salary costs, redeployment is obviously going to be less reasonable in those circumstances. I think that the illustration here is that a role is made redundant, however, a person's employment may not be, or it may be, terminated as a result of that role's redundancy. And the main reason why someone wouldn't be terminated from their employment is mainly that redeployment piece. It might also occur where an employee's duties are so significantly changed either in nature or in scope that it cannot be said that the original position continues to exist, but the employer does not propose to change the terms and conditions of the employee's employment. So perhaps it would be that they just remain on the same contract of employment that they currently have. However, there's going to be a significant redesign of the role that they were performing up until that time. So from a technical sense, that probably would constitute a redeployment in that the person is now performing a different role. But I think that it's probably a piece that's missed by some employers, possibly not thinking about it in terms of it being a redundancy. However, it is. And so it would be sensible to ensure that you go through a consultation process in relation to that. So here is a brief snapshot of the benefits to redeployment. So we've just got some categories there, such as increased flexibility. So the business and its workforce can adapt quickly to changing business needs by keeping existing staff, but repurposing them for new roles, allowing it to pivot quickly rather than having to go through a process of rehiring. Employee retention. Employees keep their continuity of service and ongoing employment with the employer. It also means employees obviously stay with the employer that they know as opposed to going and finding new employment. So I think both of those options are a little bit of a case of the devil you know is better than the devil you don't. Skill development. Given that reasonable training has to be considered and provided as part of redeployment, it allows existing employees to build their capabilities, skills, and sometimes qualifications, accumulating more and more and possibly and hopefully being even more of an asset to their employer, even if they aren't continuing to perform their previous role. Cost efficiency. So it saves money on hiring and training. Both are costly and uncertain processes. And I would also add, and I'm sure a lot of people watching would also add, that it saves money on the redundancy payments. Organisational knowledge, enhance innovation with diverse perspectives. For that one, I would also add that it retains people with intimate knowledge of the organisation and the business. Employees that can possibly use that knowledge and bring a fresh new perspective and that knowledge into the roles and departments into which they then get redeployed. Having people that are familiar with different aspects and processes and departments of a business can be very, very helpful when they're redeployed into other areas. So that's just a few of the benefits that you can see from redeployment, some of which have some overlapping coverage there. That's just to illustrate that redeployment can be of a huge benefit to businesses. So, the consideration in relation to redeployment is always whether it is reasonable in all the circumstances. So to place itself in the best position to defend unfair dismissal claims and general protections claims. The following attributes should be considered by a business when determining whether a redeployment opportunity or offer is reasonable in all the circumstances. So capability, can they do the redeployment or the other role, alternative role, with reasonable training? That's an obligation that is frequently and regularly overlooked by employers when considering redeployment, but it is an active and very real consideration that people should consider. Location, is there a reasonable alternative location from which the person can perform their work or be redeployed into? Associated entities, check for vacancies or, as we'll cover later, other work creation opportunities within associated entities, so that's corporate parents or subsidiaries. Pay and status. Any redeployment opportunity that the employee is capable of performing should be offered. So that includes the lower paid positions, positions with reduced hours, positions with reduced salary. Ultimately, it is up to the employee whether they accept or reject those offers. So we'll cover a bit of a case example later on where it shows the consequences of not offering a role in circumstances where the employer thought that the employee may be insulted by having it offered to them. And then finally, contractors, links to another case example that we'll cover, Helensburgh, which held that businesses do need to consider whether they've got any work being performed by contractors that can be freed up or insourced to create positions that redundant employees can be redeployed into.
Question from the crowd.
Yes.
So in freeing up contractor roles, is it are employers able to make an employee redundant and then bring them back as a contractor?
Look, I would say no. I would say that faces considerable risk. Ultimately, there's a bit of a consideration as to whether the employee is happy with that arrangement. For the most part, where an employee goes into these sorts of arrangements willingly, then the chance of them making a claim in those circumstances are fairly low. Additionally, an unfair dismissal or general protections claim needs to be lodged within 21 days of the termination of employment. So you'd expect that someone in that situation would probably have gone past that time limit and therefore cannot make that claim. But good question. So redeployment opportunities may not be relevant just to genuine redundancy. They may also be relevant to whether the employer has obtained other acceptable employment for the employee. Now that phrase, other acceptable employment, appears in section 120 of the Fair Work Act. And that section lets an employer apply to the Fair Work Commission asking for an order that redundancy pay be reduced, including to nil. And that's on the basis that it has either obtained other acceptable employment for the employee or it just simply cannot pay the redundancy amount. So most cases considering those types of applications generally deal with employment that has been sourced from another organisation. So the employer has gone through the redundancy consultation process and found employment with perhaps an organisation that they have a fairly close relationship with. They don't specifically consider whether or not that employment can be within the same organisation. So for that reason, we would say that there is no reason to think that other acceptable employment needs to be with another organisation. It's open to an employer to argue that employment within its own organisation, so that includes a redeployment offer, where that redeployment offer may constitute other acceptable employment and the employee refuses to accept that employment, that may be a basis for the employer to apply and reduce the redundancy payment. There are a lot of considerations that will go into determining whether it is other acceptable employment. So you're best off obtaining advice in relation to that, and it's worth noting as well that you can complete the process and then make the application to the Fair Work Commission to reduce the redundancy pay. Most of the time, realistically, it's not going to be worth the time and cost of pursuing such an application for most businesses, but sometimes it is. So get advice if you're thinking of going down that path. As the slide says, it won't be a case of genuine redundancy, and therefore it will not be an automatic defence to unfair dismissal if it was reasonable in all the circumstances for the person to be redeployed, either within that employer's enterprise or within the enterprise of an associated entity. It is also very important to note that redeployment means giving the employee the job. It does not mean giving them the opportunity to compete with other applicants, specifically external applicants for that job. Redeployment needs to be an offer of employment. So that is, if it's accepted, then the employee steps into that role. Now, you can go through a process of having employees apply for a potential redeployment opportunity. It needs to be internal employees that are applying though. And the purpose of that process generally is so that you can obtain as up-to-date as possible information regarding skills, experience, qualifications of that cohort of employees that are potentially competing for this redeployment opportunity. It also allows you to identify the best candidate for that redeployment opportunity. So again, just to reiterate, it won't be reasonable redeployment if vacant roles are secured by external applicants and existing employees are terminated without redeployment into those roles that were available during the redundancy process. It is also important to offer all vacant roles that an employee is capable of performing, and that's what that final line in the slide says. Don't hold back an offer. We touched on this earlier as well. Don't hold back an offer that you think will offend the employee. So the case there with Jenny Craig Weight Loss Centres and Margalina, it was a situation where the employee's role as regional manager was made redundant. During the consultation process, the employer didn't offer her the redeployment into a centre manager role because it was significantly less pay and significantly less hours and seniority, and they thought that it would offend an employee of her seniority and skill. Now, the employer ended up making an unfair dismissal claim on the basis that she actually would have accepted that lower paid role because it offered her more balance for her to also have for her family life. So the full bench ultimately held that it wasn't a case of genuine redundancy because it would have been reasonable in all the circumstances for the employee to be redeployed into that role. So Helensburgh coal decision, this is what I touched on a little bit earlier. It's a landmark High Court decision about what constitutes reasonable redeployment. So in this case, the employer implemented 47 redundancies. Bartley was one of the employees impacted by those redundancies, in addition to obviously the 46 others. Those employees challenged it on the basis it wasn't genuine redundancy because it was reasonable for the company to insource work that had been performed by contractors and redeploy the employees into that work instead. So it was unanimously held by the High Court that when determining unfair dismissal cases, the Fair Work Commission can broadly inquire into how an employer structures its entire workforce when assessing if a dismissal is a genuine redundancy. Frequently, we provide advice that operational reasons that lead to redundancy are more or less the employer's prerogative. For the most part, the Fair Work Commission is reluctant to step into the shoes of a business and make decisions about its operations and things like that. So, however, that stands in contrast to this decision, which admittedly doesn't relate necessarily to the redundancy of the roles, but it does relate to the redeployment of those employees that are affected. So there was a clarification that redeployment does not simply mean looking for vacant existing roles. It requires assessing whether an employer can reasonably rearrange its business operations and may include replacing contractors with direct employees to avoid redundancies. So this has significantly broadened the playing field when it comes to considering redeployment opportunities and ways to avoid or mitigate the impacts of redundancy. So due to this decision, businesses must evaluate and justify their workforce models and keep clear records of why redeployment or insourcing options are unreasonable. So this slide shows the general trend in relation to disputed redundancies. Disputes have never been higher, as you can see from the graph, and getting the process right has never been more important. Redundancy disputes have surged over the past year, with employment lawyers reporting a 20 to 30% increase in restructuring disputes. This is being driven by ongoing cost pressures and organisational changes. This growth has fueled a 40% spike in unfair dismissal claims and general protections claims lodged in the Fair Work Commission. Noting that general protections claims are actually properly dealt with by the federal court, but in the first instance, the Fair Work Commission must conduct a conciliation to see if it can resolve the matter, and if it can't, it will then issue a certificate to the applicant that conciliation has been attempted but has been unsuccessful, or that conciliation was not reasonable in the circumstances. Actually, it also needs to include a comment in that certificate as to whether or not it believes the applicant has prospects of success with their claim in the federal court. There seem to be three core drivers of redundancy disputes. So as we mentioned, economic pressures, with cost-cutting measures in sectors like retail, technology and construction, which have forced mass restructures. Automation and AI, so approximately 20% of restructuring disputes now involve artificial intelligence or efficiency tools that are reshaping the labour force rather than just eliminating jobs outright. And mixed workforces. Disputes seem to frequently arise where employers make permanent employees redundant while retaining external contractors to perform those similar tasks. This speaks again to the idea of genuine redundancy, where the job or role is in fact still required, but employees are dismissed. So this slide contains the table from section 119 of the Fair Work Act in the National Employment Standards. Note that small business employers, so those who have fewer than 15 employees, and employees will not include casuals, but it will include regular and systematic casuals. So those sorts of businesses are exempt from the obligation to make redundancy payment to redundant employees. Note that in the table there is a step down from 16 weeks down to 12 at the final couple of rows there. Now that's not an error, that's on purpose and in recognition of employees being entitled to long service leave in most jurisdictions at that point of service. As noted there and mentioned before, employers can apply to the Fair Work Commission to reduce redundancy pay if they believe they have obtained other acceptable employment for the employee, or they're just unable to pay the redundancy payment. Something that I should add to the previous information about other acceptable employment is that the application, that employers need to have gone to some active effort and obtained an offer of employment for the employee. Now that's more referring to the circumstances where it's not within their own organisation. It's those circumstances that I refer to where they might have contacts or existing relationships with another organisation, and in talks with them realise that they may need a worker and that their soon-to-be redundant employee can perform that work, and so they almost procure an offer of employment for that employee. But the case law, it's important to note that the case law looks for some sort of active activity on the part of the employer in procuring an offer of employment. It can't simply point them in the direction of an organisation that may be looking and leave it up to the employee to do the application process and be successful and things like that. It needs to procure that offer of employment for them. So, and again, if that offer is rejected, you can then apply to the Fair Work Commission to reduce the applicable redundancy pay, including to nil. For all other employers, redundancy pay must be made in accordance with that table or in accordance with the more generous provisions of an enterprise agreement or an employment contract. So this clause here is present in the vast majority of awards. It says that employee given notice of termination in circumstances of redundancy can terminate, so they can resign from their employment during the minimum period of notice prescribed by section 117 of the Act. The employee is then entitled to receive the benefits and payments flowing from the redundancy had they remained in employment until the expiry of the notice, The only thing that they won't be entitled to is payment of the notice period for any period that they don't remain employed. So it's important to note that it refers to the period of notice prescribed by section 117. So it's not the consultation period, and it's not some other period of notice that might be required under the employment contract or an enterprise agreement. It's only a consideration of section 117 of the Act. Those other ones may be more generous, and so they may be different. So to break it down, I think in an easy way, it's a consideration of what is the employee's period of continuous service, what notice of termination is required to be given under section 117 for that service, when does the employee's termination take effect, and if the employee leaves during that notice period, they still get paid their redundancy, but don't get paid the notice period that they didn't serve. So for example, an employee under the age of 45 years with 4 years of continuous service is entitled to 3 weeks notice of termination under section 117. At the end of the consultation process, the employer gives them notice, a letter in writing, that their employment will end in 3 months due to redundancy. The employee is only entitled to the redundancy payment if they resign within the final 3 weeks of employment. So now the legal risks. So unfair dismissal claims. A redundant employee can make an unfair dismissal claim. They would be eligible to make it if they have served at least 6 months continuous service or 12 months in the case of small business employers. They will also be protected from unfair dismissal if they satisfy one of 3 requirements. So one of the requirements is that they are covered by a modern award. Again, we refer back to that distinction between applied and covered. So the award doesn't necessarily need to apply to them, it just needs to cover them, which will be the case in 95%, and that's just a figure I'm picking off the top of my head, but in the vast majority of cases, an employee is going to be covered by a modern award, even if it doesn't apply to them. So the only situations where someone may not be covered by a modern award are award-free employees, where we spoke about IT, HR, marketing professionals, accountants, lawyers, managerial staff and executives. The second one is that an enterprise agreement otherwise applies to them, or that they receive earnings that are under the high income threshold. So the primary remedies for unfair dismissal are reinstatement and up to 6 months of lost wages. An employee has an obligation to mitigate their loss, so to look for other employment and to otherwise take action that stops them from having that economic loss. As we've noted, genuine redundancy is a jurisdictional barrier to these types of claims. Now, that doesn't mean the claim can't be made. That doesn't mean that you won't have to go to some cost and effort of defending them. But it does mean that in the first instance, there will likely be what's called a jurisdictional hearing as to whether or not genuine redundancy has occurred. And as we've listed there, the consideration of that is whether the role is no longer required to be performed by anybody due to operational requirements, and the Commission is a little reluctant to decide whether the operational requirements are reasonable, and in fact will almost never take that role. Whether consultation has occurred under an applicable modern award or enterprise agreement, and whether the employee was offered any redeployment opportunities that may exist. It's not a requirement that redeployment be offered in each case of genuine redundancy, but you will need to demonstrate that there was no redeployment opportunities available if you haven't offered any. The other type of claim that employees may make is for general protections. Well, a claim for breach of the general protections. So the Fair Work Act provides a number of, as it's called, general protections for employees that cannot be contravened by an employer. and genuine redundancy isn't an automatic defence to a general protections claim. The obligation for the obligation under general protections is that the termination, so the adverse action, and the reasons for the adverse action, so the reasons for the termination, that those reasons don't include a prohibited reason. So it's not necessarily that the primary reason for the termination was something unlawful or that the sole reason for the termination was something unlawful. It's simply that was one of the reasons that this person was terminated in the redundancy process a prohibited one. And that would include things like discrimination or them having exercised a workplace right or to prevent them from exercising a workplace right or on the basis of union membership. So the remedies available for general protections are reinstatement and uncapped economic loss and uncapped non-economic loss. So that's pain and suffering. And so the warning there is that, in fact, there is no minimum employment service period and no protection from the high income cap that operates for general protections. In fact, even prospective employees can actually make general protections claims.
Thank you, Andrew and Sophie. And I'm sure there are people with a load of questions, so please email those questions in and we will get in touch with you. Just a little bit more on how the SA Business Chamber can help you. We have industrial relations advice, of course, support and representation. So we do that through the Australian Chamber of Commerce and Industry if it's a federal matter, and we do that locally if there's a piece of state legislation, and that happens from time to time. There have been a couple of new ones, for example, the Workplace Protection Personal Violence legislation, which came into effect on the 4th of May. And we have have a look at our newsletter, South Australian Business News, because that has an article on it, just to raise the main issues of that legislation. We have a business advice hotline support for members, and this is a fundamental part of what the Chamber does for members. We can help you with policy contracts, with policy reviews and employment contracts. We can help you with payroll compliance audits, workplace health and safety and workplace relations training and management courses. We do monthly or more webinars, and we do industrial relations briefing for regional businesses. We have executive or management briefings on specific topics, and we really encourage you again to subscribe to the SA Business News, because that's often where you'll see the newest information coming out about the matters that we've been involved in on your behalf. But call the Business Advice Hotline if you're a member. If you're not a member, please contact the Chamber, and it's quite reasonable to become a member, and it will give you that security that you are calling somebody who knows exactly what is happening at this point. Thank you.